non-parties, PulteGroup Inc., 9 individual board members, as well as the general counsel, Sheldon.
Look at all these clients.
Very fruitful.
You're welcome. Okay, do we have an order for the hearings this morning?
Yes, Your Honor, I believe there was an order of the motions that we would take, and I think Mr. Fitzgerald is handling that.
Okay. Yeah.
Morning, Your Honor.
Morning.
As you know, we're relatively new to this case.
I'm sorry, I don't know who's speaking.
Roy Fitzgerald, I'm sorry. Since I got in the case, I've had a number of phone conversations with Mr. Postman and a number of phone conversations with Mr. Rabin and Ms. Johnson. Mr. Rabin and Ms. Johnson, myself, have been trying to work out some ESI issues. We've hit a roadblock.
Okay.
And we need some direction from the court. So Adam and I have agreed to bring it before you to just get direction. If you want to not do it here, we'll do motions. But in this case, I'm trying to eliminate motion practice.
Well, I appreciate that. I got the report. I think Mr. Raven filed that. It was, or Ms. Johnson.
That's one of the issues I wanted to speak about. So your order of August 22nd laid out a procedure for them to follow. They collected all the data from the 10 record custodians across the 25 search terms. That created about 130,000 files. From those 130,000 files, they then ran a second screen, not an attorney screen, but a second screen, Brandon.Jones at PulteGroup.com, which reduced it to about 5,700, almost 5,800 files.
Okay.
Those are the files they're proposing to produce to us. Your August 22nd order is completely silent on this calling of the data to create what they call the Brandon Jones data set. And I understand from talking to Mr. Rabin, there were discussions at July 11th hearing on such a procedure, but it's not in your order. And I remember a long time ago, courts intentionally end orders. So we're at this roadblock as to whether this calling is allowed or not, and we just need some directions from the court.
What's your position on it?
My position is the order prevails, and it doesn't have that calling in it, so they don't get to call it. We get the 10 custodians across the 25 search terms.
Okay. Mr. Raven, do you want to be heard on this?
Briefly, Your Honor, Fitzgerald and I did talk briefly outside. He wanted to
Your name.
Adam Rabin on behalf of, in this circumstance, non-party PulteGroup. Mr. Fitzgerald and I talked briefly outside. He's been traveling the last couple of days, so we haven't been able to talk in the last couple of days. I agree that we could address this issue he's raised today, but I prefer to do it when we're making our argument because they have a pending motion for sanctions. This kind of ties with that. I'm going to point Your Honor to the transcript excerpts.
Well, I kind of hope that the sanctions motion was moot, but
I do too. But
maybe not.
They still have it. Okay. So we will address if I wanted to do it in my argument, so I can point you to the transcript excerpts.
Okay.
Okay.
All right. So what are we going to hear first?
I think they're doing chronologically today, Your Honor.
Okay.
So, Your Honor, this is William Beal on Zoom. I'll just give a brief intro to the background of the motions. I think Ms. Savage will argue the first motion, but nearly all of the motions that plaintiff has noticed to be heard today are related to efforts by PulteGroup or Jones to stifle plaintiff's efforts to do what you ordered us to do when you granted Ryan Marshall's motion to quash his deposition based on the Apex doctrine, and that is to explore and exhaust sources to obtain relevant discovery to prosecute plaintiff's claims. So we're here today because today PulteGroup and almost all of the employees that have had document subpoenas have refused to give any discovery. The lone exception to that is 5 pages of text messages which were produced by PulteGroup's current director of market intelligence and a former director of field operations initiatives who is separately represented. And not only that, in our view, PulteGroup has refused to cooperate in very basic ways. For example, the oral order that you gave at the hearing on July 11th to transfer the emails from 10 custodians based on 25 search terms into relativity. And so we have, as Mr. Fitzgerald said, we have been meeting and conferring about that, but we were told in a meeting on July 16th that PulteGroup was simply refusing to do it. And that's what prompted the motion for sanctions or for show cause to contempt. We did receive a search report on Monday at 10 p.m., but we have lost 6 weeks of time in getting it. We've spent a lot of money in getting it. I think the only reason why we got it was because of the pending motion for sanctions. It's not that we want sanctions. We just want to get the discovery to move the case along. The other example of that, Your Honor, is you also ordered that Ryan Marshall produce documents responsive to the subpoena served on him on July 22nd. Did he do that? No. He filed a late motion for extension of time after asking for an extension because he would be on vacation, and then filed what we believe is a motion for rehearing. It's summarily denied. And now he's filed an appeal, which we believe has no chance of success. So and there's nothing controversial in what you ordered him to produce. So what we're getting is stonewalling, if you will, on behalf of the group. So last Thursday, literally right before the Friday hearing on the 23rd was scheduled, Stephanie Byron, who is separately represented and is PulteGroup's current director of market intelligence, and reported directly with Jones, produced 5 pages of highly relevant text messages between her and Mr. Jones that were not produced by Mr. Jones. So this was the first time we saw these, was last Thursday. And I will tell the court, I'm not sure if Ms. Byron's lawyer is on the Zoom, but it was produced pursuant to your agreed confidentiality order. But Carrie Savage could hand you up copies.
Can I just ask a question? Are we doing opening statements?
I-
I'll do one. At this point, I'm going to ask for one. I didn't think this was a trial. We were here on motions.
Well, I'm
This
just
is set for today. I'm okay because I can go on the fly, and I'll ask before we start. I'd like my opportunity to respond, but this isn't the procedure we generally follow here, as far as I understand it.
Well, you seemingly
I'm
have.
sorry, who just spoke?
That was Barry. I'm sorry. That was Barry Postman.
Thank you.
Okay, let me say this, folks. The next time we have a hearing, I want the court reporter in this courtroom, okay? I think I said that last time, and it isn't happening. But, okay, she's doing the best she can, but it's an impossible task without a camera and without, it's just, we're too good for this. Don't need this. Mr. Pony statement, Mr. Beal, where are we going? What do you do?
Yes, Your Honor, I understand. I'm just giving background because all these facts pertain to every single motion that is going to be before you. And so,
Papers.
okay,
I saw what's in there. I understand your frustration about not getting discovery and about not being able to progress in this case. I got that.
okay,
Now tell me what you want me to do in order to assist in that process.
okay. Well, the first thing Ms. Savage will argue is the motion related to former PulteGroup employee Michelle Harrison, documents from her which Defendant Jones has objected to. We're asking you to overrule those objections, that the subpoena would issue, and that Ms. Harrison produce the documents that have been subpoenaed.
Okay, thank you.
All right, this is Carrie Savage speaking. As Mr. Beal just noted, some background here as to who Ms. Hairston is.
Sorry.
She's
There's feedback. I can't understand what you're saying.
is doing better.
No.
How about this one?
Not really. Is anyone else having the same issue? Attorneys?
Just you.
Can you get somebody from your office? This is Cheryl Coleman.
Is
This
this one-
is Barry Postman. Is there possible you can get someone from your office to come down to the courthouse? It's across the street, if I understand from your, I think Mr. Fitzgerald hired you, but we're happy to help pay for it if that's the issue.
I will email them, but go ahead.
Is this one any better?
Yes.
Okay, and I will just do this one. Okay, Your Honor, Ms. Hairston is the former head of HR for PulteGroup. And she also has, based on discovery to date, we know that her and Mr. Jones spoke frequently, including over 60 hours of phone calls since his termination or since notification of the Twitter activity to the board. Also through a variety of text messages. So we're seeking various documents from her. We have, since the July 11th hearing, conferred with Jones's counsel to narrow down some of the issues. Unfortunately, we still have one issue remaining. I would, if Your Honor is allowed, I would like to read into the record what our agreements are, just so it's all clear and we don't have to come back and fight about it.
I'm all in favor of agreements going in.
Okay. So first, Jones raised a procedural objection, and it was not filing the notice of intent to serve the subpoena with the actual subpoena. They withdrew that because we immediately corrected that issue. Also, Jones's counsel agreed to keep in request number 4 and 6 based on your prior rulings. We agreed to revise request number 2 to say documents and communications referencing the termination of Jones by PulteGroup in connection with Jones's Twitter activity. We agreed to revise number 7 to documents, including but not limited to phone records and text messages, evidence and communications you had with any other officer, director, or manager of PulteGroup about this lawsuit or about plaintiff or Jones in connection with plaintiff's lawsuit against Jones. We also, based on the documents that we recently received from Ms. Byron, we added a new request, which Jones's counsel has agreed to. And that new request is documents and communications referencing any potential rebranding of PulteGroup Inc. associated with plaintiff or any claims made in this lawsuit. So the one document request that we remain at an impasse is document request number 1. It was originally written as documents and communications referencing any proposed promotion of Jones at PulteGroup, including but not limited to his proposed promotion to Chief Operating Officer of PulteGroup. The reason we are seeking this is because in the third amended complaint, paragraph 122, we allege that Jones's Twitter activity was in retaliation for my client blocking his promotion to COO. Hairston specifically, as her role in HR, would presumably have knowledge about this, and given her relationship or frequent communications with Mr. Jones, we expect that it's reasonably likely to lead to the discovery of admissible evidence. We worked on trying to limit the request due to some breadth concerns, which we don't think are valid because this is all in her, it's to her individually. It's not to PulteGroup, so it's only documents in her possession, custody, and control. But nonetheless, we have proposed a limitation, and we have a copy of that if you would like to see it.
Okay, what's the limitation?
It is basically to reference it only to the promotion to the Chief Operating Officer. So it's basically, instead of all promotions or potential promotions, it would just to that one position that we believe, kind of led to this conduct.
Okay,
Do you want to see this, Your Honor?
sure.
Okay.
Thank you. Okay, so this is the last issue?
This is the only request left, Your Honor. And
Okay,
again, we think because it's her possession, custody, and control, it won't be too broad, and we think it's certainly relevant given the allegations in the third amended complaint.
these are the emails you gave me, those are texts, those are between her and the defendant?
Those text messages are between another, actually current PulteGroup employee,
Okay, what employee?
Miss Byron, Stephanie Byron.
Okay, all right. Yes, sir.
Judge, this is Barry Postman. We're gonna do the same thing that counsel did and give a very, very brief background synopsis. I'm not gonna go tit for tat and point out what I think is inaccurate, but I do want the court to appreciate what we think the case is about, because there's a difference in terms of what we think the case is about and where we think the case candidly has gone a little bit off kilter in terms of where it needs to be. I'm going to have my colleague address, just like Ms. Savage did, the specifics. I'm not going to be lengthy, I promise. I see you're shaking your head. Barry, I got it. I understand, Judge. But for the record and my client who's here, I want to make sure I say the following. This is a case about some unfortunate tweets that my client sent. It's a defamation case, Judge. At the end of the day, there's going to be legal and factual arguments about whether they're opinions, whether they're false, and whether they caused any damage.
Right.
And either Your Honor is going to grant a summary judgment or the jury is going to decide on all of those issues. What we're doing now, and background, Mr. Pulte was a member of the board of the PulteGroup. My client was an employee of the PulteGroup. There clearly are, and I think Your Honor is aware on other motion practice, emails and tweets and publicity associated back and forth. We are reasonably concerned, I'll use the word from counsel, that this case has become a vehicle for issues unrelated to this case, and the discovery associated with this case has become about something completely irrelevant to what's in the issue in the complaint.
Okay.
I'm reasonably concerned the allegations, and we'll get to it at some point, our motion to dismiss, have been included for reasons unrelated to what we are here for today. Reasonably concerned. I'm worried that every time they say something and I don't respond, my client said, why don't you correct their accuracy? Because that's not what we do, Judge. And that's not as an officer of the court. I'm not going to sit there and tell you she's wrong and that didn't happen. I'm not going to address, it's not the time, it's not the forum, but me not doing so is because I understand the process, and it doesn't mean because I agree to it, Judge. But I do want to make sure I say this. This case is it's a defamation case about some unfortunate things my client said. And there's legal issues, there's factual issues, and there's perhaps damage issues or not. And I just want to make sure we remember the parameters of what the case is, because I think what it's becoming, there's motions for sanctions, there's orders to show cause, there's tweets that have gone out, there's violations of orders, all of which you're going to address. But at the end of the day, we're here about some tweets between 2001 and 2002, and asking questions about promotions, and asking questions about his new job, and asking questions about his wife, and asking questions about Mr. Raven's client, and they're asking to take the depositions. There could be another reason for it unrelated to this case. I'm just saying that as my opening and my background. Hopefully I was loud enough so the court reporter could hear me. I'll now turn it over to Mr. Walker to address this specific issue.
All right.
Can you hear me okay?
Introduce yourselves.
This is Hunter Walker on behalf of defendant Brandon Jones. So I think our key issue is, that this was the head of HR at PulteGroup. And we have, earlier in front of the courthouse, Perry and I were speaking and I said, we can agree to a request that might include conversations around the alleged retaliation of these tweets associated with Mr. Pulte blocking any promotion of our client. But what they're seeking here, I think, is essentially potentially a runaround to our our client's entire employee file, which could include, as the head of HR, anything regarding this could include screening, it could include referrals, it could include background checks, things of that nature. And I think that's where our concern is. So we're happy to tailor it to the alleged, interference or the alleged something tangible to the complaint. But as it is now, I don't think it meets that
So the requested modification is documents and communications referencing the proposed promotions of Jones to Chief Operating Officer of PulteGroup. How does that impact the things you just mentioned?
Well, as the head of HR, I think it's possible that she would have, as a promotion, I imagine that they include interviews, backgrounds.
Interviews of who?
Our client, it's his promotion that there's
promotion.
Yeah, I understand.
So as it relates to our client's promotion, if she had documents of communication surrounding that, all these, there are multiple considerations for something like this. This was a large company, a high role at that company. I'm sure there could be potentially extensive information about our client in relation to this promotion. And we're concerned that this request as tailored doesn't.
What's your client's position on promotion? Is he going to talk about it during this case?
No. Did I say that? Gary Postman, the answer is no.
So are you making the argument, Mr. Postman, or is your just one, okay? You can, I used to have little yellow slips of paper and I'd write, tell them no on it, okay? You can do that.
I'll get him a note.
Get him a little pad to write.
No, I mean, we don't think there's any relevance to this promotion. I mean,
So I'm not going to hear about deserving or undeserving he was from your team.
there's an affidavit which our client submitted with an earlier motion at one point. I believe it was with prior counsel on the first motion to dismiss. And he testified on this affidavit that he had no knowledge that Mr. Pulte opposed the promotion.
Well, that's not the issue.
Well, right. I mean, I don't think there's anything within his promotion that's relevant that we anticipate would ever be relevant to the claims, whether these are defamatory tweets, anything of that nature.
So you think the whole file is irrelevant?
His employee file?
This documents and communications referencing the proposed promotions of Jones to Chief Operating Officer at PulteGroup. You think that is entirely irrelevant and will not lead to the discovery of.
I don't think it's relevant at all. And I don't think there will be any admissible evidence that comes of that. That being said, and as I spoke with Gary, I'm still happy to tailor it to the complaint if that's, something that they think they need to look into. But no, I mean.
Okay. Ms. Savage, why is this?
Well, one, Your Honor, it is tailored to the complaint. As I mentioned, we believe he was motivated by blocking with his promotion. And I mean, Mr. Raven can state PulteGroup's position, but I suspect it would not be terribly pleased if his entire employment file is in her possession, custody, and control as a former employee of HR. So I don't think there's any real breadth of concerns.
We're not talking about the entire, you've carved that out.
Right.
Okay. So I'm not sure what the issue is here, really. If she has these as a former employee, how's that?
Well, I don't know. I mean, I guess there's potential that she used her personal email at any point. But I mean, she was the head of HR. She wasn't just an employee of the HR. But I mean, I think there's a relevance, which I think you were getting at as it relates to the promotion at all. I mean, as Ms. Savage mentioned, they included this allegation in their most recent complaint.
This is pretty clearly pled, isn't it?
In the most recent complaint?
Yes.
Yes. Yeah, they do include that.
Okay. So the objections are overruled. The modification is accepted by the court. How long will production require?
It's third party.
Okay.
I'm sorry, someone just spoke?
This subpoenas to a non-party, and I don't believe her counsel is here today.
Okay.
Who just said that?
One moment, because this is Joe Gallardi. I am the attorney representing Ms. Hairston.
Okay.
I am here just observing. I didn't intend to make any argument today.
All right. Thank you for appearing, and nice to meet you, sir. Okay. So have you served the subpoena on her?
Not yet. We were waiting for this agreement. We will promptly modify it per our agreement in your order and get it issued and served.
Okay.
I'm sorry, that was garbled. I didn't understand you.
Okay, this is Carrie Savage on behalf of the plaintiff. I said that we will promptly get the subpoena modified per the agreement with defendant's counsel and the court's order, and get it issued and served on Ms. Hairston.
Mr. Gallardi, do you want them to send it to you for service, or do you want them to serve your client?
I'm going to have to consult with my client first, but I will certainly speak to defendant's counsel after the hearing. We can discuss that.
All right, thank you, sir. Okay, what's next?
Next on the docket is the motion for sanctions against PulteGroup, and so that would include the conversation earlier about the PulteGroup case.
All right, we're in context now, Mr. Raven. Go ahead.
Your Honor, it is our motion. It's fine if you would rather hear from him first.
I would. I read your motion. I'd like to hear where things are at. Let me, hopefully this is the mics. So I've never had problems with the mics at the podium before. And I don't know. I think it's just the core reporter, but maybe not.
Your Honor, if I may.
Yeah.
US Legal just told me that they only have a digital court reporter available, not a steno. I am a steno. You guys have my April 24th transcript on this case.
Okay, we're going to do the best we can. You keep telling us until, and we'll do the best we can. And next time around, I'd love it if you could join us though. Okay.
Yes, Your Honor. I'll try. One quick trick I can tell you is the attorneys, it's not a volume issue. For example, Mr. Postman, your mouth just needs to be right on the mic.
Okay, thank you.
Thank you, Your Honor.
Adam Raven on behalf of non-party PulteGroup with respect to this particular motion. Your Honor.
Okay.
With respect to the issue that Mr. Fitzgerald had raised. First, you've read the papers. I don't want to belabor them. At this juncture, as of last week, we had fully complied with Your Honor's order. We filed a notice of compliance.
Well, that's the way it looked. I mean,
Yes.
when I read your report.
Right. And just to clarify, since Monday, it was actually on Tuesday evening, the plaintiff filed a supplemental memorandum in support of their motion for sanctions, which certainly was outside the requirements of notice for 5 days before this hearing. And so we've kind of had to review it. There's a lot of new argument requests in there. So we submit that it's really kind of a morphed motion or an amended motion, Your Honor, and that Your Honor should not consider this additional relief that they're seeking. But I want to get to the issue that Mr. Fitzgerald raised. So again, we're 100% compliant. The transfers occurred to relativity. We have produced to them fulsome hit reports as required in the August 22nd order. There's 12 different reports. 10 of them are one per custodian for every search term, all 25.
Okay.
And there's also 2 summary reports, one by all custodians and one by all the search terms. Exactly what Your Honor ordered. The order says nothing than that. So it's the detail we submit. We were obligated to provide, and we've provided in full. It's all in relativity. The issue Mr. Fitzgerald is raising is a slightly different issue that wasn't expressly addressed in the August 22nd order, but it was something Your Honor ruled at the hearing. And if you're able to turn, Your Honor, to it's tab 2, but it's exhibit A to the motion where they attached the transcript from that hearing.
Okay. Give me 1 second. All right.
And if I can turn your attention, Your Honor, to starting with page 43, which leads into page 44. It starts on line 13 on page 43. It should be, I'm not sure if your version is highlighted because it's their book.
It is.
Okay. So this is where Your Honor addressed this specific issue. It was one of the primary arguments that I made. If you may recall, we gave a demonstrative, a couple different exhibits and what the volume of data was returning from each of those. And Your Honor made the ruling that it was 10 custodians and 25 search terms.
Right.
So what I was arguing at the hearing, and Your Honor ultimately agreed, was that once the data is transferred to relativity, that the initial production would be limited to Brandon Jones on the communication, whether it's a to or a from or a CC or BCC. And then Mr. Beal came back up and then kind of tried to get it modified. Your Honor stuck with its ruling, but then said it's without prejudice. And that's basically what happened. I'm just going to point you to the language.
Right. All the discovery rulings are without prejudice.
Correct. And you've been very consistent with that throughout all of these hearings. So what Your Honor said, starting with line 13, is so the motion to quash is denied. The motion for protective order is granted in part. What I'm going to do, I'm going to accept in large part Mr. Wood's suggestion, but I'm going to limit it to 10 custodians and 25 search terms. So I'm cutting in between search 4 and 5, and that was referring to my demonstrative chart. Mr. Raven's suggestion that it also be limited to emails involving Mr. Jones. Is that what you're seeking? I want to make sure I get this right. Mr. Raven, yes. The court accepts that suggestion without prejudice. Plaintiff will need to establish a basis to search further as to all of this. The ruling is without prejudice. And then if you turn, Your Honor, just briefly, because this is where Mr. Beal asked for clarification, page 49, line 4. Mr. Beal, just to be clear, because the order is without prejudice, so we will have the opportunity to go back after some discovery and show we need to go beyond just emails that Mr. Jones may have been on the court. Absolutely. So that was Your Honor's ruling at the hearing. The initial production would be limited to Jones because that's really what they're trying to prove here, which is some intent element to their causes of action. And if there's a reason, maybe that's sufficient. If it isn't, then they're going to be able to raise that with us and ask for either a variation of the search terms, which were really, frankly, very overbroad, so a lot of them were one-word search terms, or they're going to come back and say we need an additional 2 or 5 search terms. And so we just asked that, Your Honor, that's what you ruled. We made very fulsome arguments back and forth, and Your Honor, stuck with its ruling. We ask that you do so today.
Okay. Mr. Fitzgerald?
Briefly, Your Honor. In your, Coach?
Yes, sir. Thank you. Okay.
In your August 22nd order, this limitation is not contained.
I'm sorry.
And we all know.
I can't make out what he's saying. Apparently both podium microphones are having issues. They're both garbled, just so you guys know.
It's funny because in the courtroom they're clear.
It may not be the microphone you're on.
I'm not sure what's
Can the
going
other
on.
attorneys jump in and let me know if the mics are garbled?
This is Roy Fitzgerald. I'm sitting at council table. Can you hear me now?
Hang on a second. Let's find out. Mr. Beal, is it garbled? You're on mute.
Right. Yes, it is on the one microphone. I don't think it is on the one that Mr. Fitzgerald is using that right now. It's not great. It was better when Kerry was speaking at the council table, but it's better than the podium on the left is.
We'll get some people on it. Okay. So let's use the mics at the desks if you can. Do your best, Mr. Raven. We're out of desks. Okay, Mr. Fitzgerald.
I read the transcript. As I started to say, in your August 22nd order, this limitation is not contained.
Let me suggest this. It's all without prejudice. Why is it that you're asking me to do what you're asking me to do?
Because I want to get the data and get this case moving.
And what will the change or the modification or lack of it, however you want to characterize it, how will that help in that regard?
We're getting 1 record custodian. You ordered 10.
Right.
We're getting 1. We're getting Brandon Jones' house. We want the other 10 custodians' emails also.
Mr. Raven?
Your Honor, that is inaccurate because we have produced the 25 search term. We have identified on the hit report the 25 hits for all 10 custodians. The only restriction that we submitted, which given what the issue is in the case, Your Honor accepted as reasonable as we just went through, because it doesn't mean it's his inbox or his outbox. It just means he's on it somewhere. He can be copied on it. He doesn't have to be the author. He doesn't have to be the recipient. He has to be a CC, BCC, or the author or recipient. So it includes all 10 custodians. We fully complied with what Your Honor ruled. And given that is the issue here, going beyond that is really what kind of got rejected at the last hearing with Mr. Beal, or conversations where people might be gossiping. If Brandon Jones is not on communication, presumptively, it doesn't matter. And so that's why Your Honor entered that limitation, again, without prejudice, and that's the way it should be until they make a showing otherwise.
Your Honor, there would have been no reason to engage in collecting a universe of data of 130,000 files if that is what you actually ruled, because they could have just taken Brendan Jones and give us his inbox. And that's not what you ruled. And what they're trying to do is just morph this into something that you didn't rule. Your order, August 22nd, is clear.
Yeah, it's 10 custodians. So maybe I'm.
So we should get the entire universe of data after they run the attorney screen. That's how ESI is done all the time.
Well, and why aren't they getting that?
They have a hit report that
I'm
shows
sorry.
all.
Guys, I don't know when you go back and forth with the judge who's speaking.
Okay, this is Adam Raven now
Who
speaking.
spoke to the judge just now before you?
Roy Fitzgerald.
I'm sorry?
First name's Roy, last name's Fitzgerald.
Thank you. And now it's Mr. Raven. Thank you.
Yes, it is. So, Your Honor, to address your question, what Your Honor ruled at the hearing and is reflected in the August 22nd order is that we would give them the hit reports for the fulsome information. But when it came to an initial production, you accepted my argument that it should be limited because Brandon Jones and what he knew is the only argument that they've made. And at least initially, unless they make a showing otherwise, would be a production because it would greatly reduce the amount of documents we have to review for responsiveness, relevance, or privilege. And I want to take you back to the rationale because Mr. Fitzgerald wasn't engaged yet at that time. But what Your Honor decided at the hearing was that we don't want to have to do this twice, right? You accepted our argument as to what should be produced. But you said, why don't you transfer the larger data set to relativity so we're not going back and doing a do-over here after incurring those costs?
Yes, I'm fine with
And that's what it was.
Okay, but what about the 10 custodians?
The only restriction, so it's 10 email boxes, right? Responsive to the search terms. The only addition is that Brandon Jones is on the email, meaning he sent it, received it, or he was copied on.
Well, both of you guys seem sincere, okay? I don't know which one he is. He says 1, you say 10. What's?
May I address that?
Yeah, please, because I'm not following it.
I don't want to speak to Mr. Fitzgerald. I mean, he's certainly very capable, but I think what they're doing is they're sort of arguing de facto, Your Honor, that if you put Brandon Jones on the communication, it's effectively like it was his inbox, but we're actually producing separate emails from each of the 10 custodians. He just has to be included.
You mean he has to be someone sending, receiving, or copied on the message?
That's it. And that was the limitation for the purposes of what Your Honor was considering the allegations of relevancy. And if they had a reason to go beyond that, given what they're trying to show is intent. And if there's a reason to go beyond that, which really, reasonably being.
I don't know. I'm always a little skeptical when the opposing counsel tells them what their intent is, or what their argument is. I'll let them frame it. Okay. You can frame yours and they'll frame theirs. Okay. So,
Your Honor, that microphone is also getting worse. I'm just letting you know. I'm assuming the attorneys will agree.
my microphone too?
No, you're always perfect. Your audio.
How about the witness box next?
Okay. Okay. So, Mr. Fitzgerald, what is it? Tell me what it is that you're seeking here.
What I'm seeking is how ESI is done all the time, Your Honor.
Just tell me what you
They
want.
collected the data, run their attorney screen, give us what's left. That's how ESI is done. The
We're-
arguments about they have to go through the whatever's left, let's say it's 100,000 documents. They have to review them for relevancy. That's not what you do. We'll get to relevancy when we get to trial. I mean, right now, is it reasonably calculated? In ESI, you get a lot of leeway.
So you want,
I want what's ever left over. I want the residual data set after they run, they claim they've deduped it. Now run your attorney screen, give me what's left. That's how it's done.
okay, why not?
Okay. So aside from what we actually spent a lot of time at the last hearing, Your Honor agreed with us that it should be limited based upon what they've alleged in the complaint. The reason that that is way going to be an overburden for us is because we've taken a glance at some hits. For example, one of the search terms was fire. And in the context in which they're looking, it appears to be because there was a tweet about a fire at a country club. But what's actually happening is, you can imagine, having done employment work for many years,
Sure.
every time there's a reference to an employee potentially getting fired, having been fired, all of these really thousands of false positives are coming in. And that's what's happening with all of their search terms. So it's going to be an inordinate task to have to review, these documents that are not responsive, they're not relevant, yet there's a word in it because of the way that they did these terms that makes it incredibly burdensome and creates really, in some cases, hundreds, but in some cases, thousands of false positives.
So what's in relativity now is what?
It's the entire 25 search terms and the entire 10 custodians that's there.
Okay.
What we're saying that we would want to produce initially is what you're on the road, which is at least at first the communications with Jones on them, and then if there's a need to do that, then they can.
Okay. And you
Sorry,
give,
was this Mr. Rabin? Just
Yes,
speaking?
yes.
and you've given them those.
We haven't produced any documents yet. We've only given the hit reports.
Okay. Why
I
not?
didn't understand what you said. We haven't?
We have not produced any documents. We have only provided the hit reports. And to answer your question on it, that's because that's what the order provided. We were required to provide the hit reports. So your rulings were is that once you get the hit reports, assess them, confer further, which is kind of how it's a flow process. It has to work that way.
Okay.
Can I just one thing? Just right still speaking. This idea that there's false hits in there happens all the time.
Right.
I mean, we'll just apply some power against it and run Jones and fire. But that's on us. They don't need to do this. They've done what you ordered them to do. Run the attorney screen and just give me the residual.
What they've found so far.
Correct.
All right. That's what I want you to do. Within 24 hours, I want you to turn that over, and then you all work on any modifications, try and work that out. But Mr. Fitzgerald, look at what you're getting, and then talk to Mr. Rabin about if there's anything else.
Absolutely. I mean, we've been talking 2-3 times a day.
Okay. So we'll see.
Can I address?
Yes.
With the amount of data, Your Honor, it's been distilled to 166 gigabytes, which overall would be.
The microphone is not
Yeah,
fairly.
and come back here.
I just can't understand it.
I'm gonna try one more time. Can you hear me?
It's not, it's garbled.
Let's try the next one.
Kathy, would you call IT or go tell Lucille to call IT and have them come on up? Thank you.
Can you hear me? This is Adam Rabin.
Jennifer, are you there?
Yes, I am.
Okay. Try again, Mr. Rabin.
Jennifer, can you hear me? This is Adam Rabin.
Perfect. Thank you.
Your Honor, 24 hours to produce what potentially is in that data set would be millions of pages of documents. We wouldn't even be able to review for privilege.
Oh, you haven't reviewed it yet?
Oh, no, we haven't even seen the data. We'd only taken a glance at a couple things that was responsive. It would take us honestly a substantial period of time to go. That's why we're trying to narrow it to reduce the burden as to what's not only responsive, but would be relevant, but absolutely privileged. We can't waive our ability to review privileged documents. Mr. Fitzgerald and I have talked about that. He wants us to be able to just do a computerized search term and then produce everything else, even if privileged documents get produced, we would have a clawback right, but that is not sufficient. We can't waive a right and produce privileged documents, potentially get caught up in there. And then, you can't unring the bell once you've done that. So we would need that volume of documents, Your Honor, if you're going to expand it. That's why we wanted the Jones limitation and what we argued at the prior hearing, but it would take us at least 30 days to do that.
All right, so we're going to do rolling productions here. You got 10 days to do your first wave, 10 days to do the next, and then 10 days to finish. Mr. Fitzgerald, you and Mr. Raven can do some talking and time together and work through the remaining issues.
Your Honor, just briefly, this is 2024. You don't review these things. You run your search screen. You have a clawback agreement. You produce the stuff. This is like just labor that's being expended for no reason. I mean, I just finished a case down in Broward that had.
I don't doubt what you're saying, but got two lawyers telling me their views on these things. Next time you come, bring your e-expert with you, okay?
She's in the courtroom.
Okay. You want to testify? You're about to.
I'm sorry.
You don't
Just
do
go to the
testimony.
attorney.
Next time, have her ready to go, okay?
Okay.
All right, so I'm hearing argument, not evidence. That's what you got. Mr. Raven, please. Things have to flow, okay? I'm indulging this as much as I possibly can. All right?
Yes, Your Honor, just one more thing in that note.
One moment, please. I need the name of the attorney that just spoke to the judge back and forth.
Adam Raven.
No, that was Mr. Fitzgerald. Mr. Raven's about to speak.
Thank you, Fitzgerald. Now it's Raven.
Adam Raven, to address that, Your Honor, my client's a large company and it's not necessarily that easy to do something like this in 10 days. It was not an issue that was even set for hearing today. And so I haven't been able to talk to them about this in advance.
Do the best.
Whatever your rule.
Do the best you can in
Yes.
10 days. Whatever you can get through in 10 days, turn it over, okay? And then 10 and 10 and we'll be done. You got your 30 days, but I'd like to see some progress.
Okay. And if there's any exigency, I would just ask for permission to raise it with the court, but whatever Your Honor rules, we will do our very best to honor it. And if
After you talk to Ms. Fitzgerald, then come see me and bring your experts. If it's going to be an argument over we can't do this or it's too much, lawyer argument isn't going to cut it on either side anymore. Okay?
fair enough. Thank you, Your Honor.
Sure.
Thank you, Your Honor.
Okay, what's next? So I'm deferring on the motion for sanctions, Mr. Raven. And if we get to 30 days and progress isn't being made, it's not going to go well for your side.
Gary Savage, counsel for plaintiff. Next up is the motion. These relate to the Sheldon and board subpoenas.
Okay,
So I think the official title is our motion to compel document production by Todd Sheldon and 9 members of
I'm
PulteGroup.
sorry. I'm not understanding. Can you please put the mic maybe a little closer? It's not volume. It's garbled.
This is Gary Savage, and we are about to argue plaintiff's motion to compel
No,
document.
it's not working. It's garbled.
If I can assist quickly, putting your mouth closer to the mic is actually going to make it more garbled because you're going to affect the sensor more. I would not do that.
Okay, is this better? I'm a little further from the mic now.
I think it is.
Okay. So we are about to argue the plaintiff's motion to compel document productions from Todd Sheldon and 9 board members of PulteGroup. So just as some background, Your Honor, Todd Sheldon is the general counsel of PulteGroup Inc., but he also serves as their corporate secretary and as a vice president. And the remainders, I'm happy to list them if you'd like, but the remaining subpoenas here are all current and former board members of PulteGroup. This subpoena was issued on June 14th. And if you recall, you last got to see us, or not last, but you did get to see us on June 13th. And at that hearing, we discussed a subpoena to Ryan Marshall, and we discussed documents specifically. And you agreed to three tailored document requests to Marshall. And the only limitation imposed was the time range here, which is February 21st, 2021 to the present. So the next day, having had the benefit of your order, we issued these subpoenas. The document requests here are substantially similar. Some of them are very identical. Differences are actually narrowing it. And we also did specifically include the time limitation that you wanted us to impose with Marshall. Nonetheless, we have now received objections here. And the objections should be overruled for the same reasons why you overruled the objections that Marshall raised. So the third amended complaint specifically alleges that Jones's Twitter activity interfered with my client's business relationship with PulteGroup and also his general reputation with PulteGroup. And frankly, both the documents and the depositions of these people are essential proving that, because what we have to show at trial is here was his reputation and his business relationships before Jones's activity, and here is this relationships and reputation after Jones's activity, right? How are we going to do that unless we talk to these people at PulteGroup, unless we talk to the board members, we talk to the executives? So that's why we need those. One of the reasons it's also relevant to show, for example, Jones' falsity of some of his statements and knowledge of it.
Yeah.
And then also in the recently produced Byron text messages, there's a suggestion that of some rebranding at PulteGroup due to the name association with my client, which of course, suggests, is that why Jones did this whole campaign, is to destroy his name and allow executives to push a rebranding of PulteGroup. These are just a variety of ways in which these documents are relevant, and it's consistent with your prior rulings on document productions as well.
Okay, so this is just seeking documents from others that that won't be. You don't anticipate these will come from PulteGroup itself.
Correct. These are in their personal, possession, custody, and control.
If they have.
If they have them.
Okay. All right. And all right. What's the response?
Adam Raven, Your Honor, for General Counsel Todd Sheldon, as well as the 9 individual board members for PulteGroup.
Okay.
Just to clarify, Your Honor just said it, but even though Ms. Savage had referenced depositions, the only issue today is documents.
Right.
So the individual board members, as well as Mr. Sheldon, have filed, similar to Mr. Marshall, Apex motions for protective order that will be set for another day.
Okay.
I just want to note, Your Honor, I would actually suggest that those motions have been waived because they weren't timely raised. This issue was,
we're not arguing that today. Okay.
I understand.
So keep that powder dry.
Okay. I will keep it dry.
Okay. Go ahead, Mr. Raven.
Thank you. What I want to say up front, Your Honor, is that there are 9 individual board members, and we have gone and checked with each of the 9 to figure out if, however many of the 9 actually have documents, which is something Your Honor just touched on. We've confirmed that.
That's where I'm heading.
Yes.
Okay.
3 of them do not have any. And we have informed plaintiff's counsel of that. They are board member Cheryl Grice, Lila Snyder, and Philip Holloman.
Okay.
The balance of 6 have some documents, which we will address.
Okay.
So as to the document requests that are directed, I think I want to focus on General Counsel Todd Sheldon first, because that's a unique position. That's not the same as the board members. And he's the top legal officer at the company, everything legal.
He's in-house?
Yes.
Okay.
So it all comes either through him directly or one of the assistant or associate general counsels underneath him. So with respect to him, even though we have previously stated, and the requests are similar to what the ones that were directed to Mr. Marshall, and you've addressed those as far as overbreadth and relevancy. But what I would submit to your honor is that, particularly with respect to Mr. Sheldon, when the arguments occurred with respect to Mr. Marshall, and just to refresh, you granted the protective orders to the apex motion, you imposed a time limitation, and then you said he had to produce certain documents that basically there were 3 requests that were left.
Right.
He had to produce those.
Right.
And those are still at issue, which will be addressed in a little while. So what essentially has happened is that since that time, your honor has dismissed the intentional infliction of emotional distress claim, as well as the without prejudice tortious interference, which is another issue that's separate today.
Right.
And I believe that that's been dismissed a couple times. So we'll see what happens with that, but they have tethered in their motion to overrule all of the objections, including Todd Sheldon's, their arguments to those intentional tort claims. And so, we submit that at least with respect to, the relevancy grounds that your honor previously had dealt with and treated, the circumstances are a bit different today, given some of the dismissals of the claims that they were arguing that they were relevant. So let me just say that as a backdrop. But I think that
you said arguing that they were relevant and
towards. I think that they were relevant as far as the argument towards. The arguments that they made were relevant towards the intentional infliction and the tortious interference claims. One has been dismissed with prejudice. One has another motion to dismiss that's pending for today.
Okay.
All right. And so I think the thrust of the argument that makes Todd Sheldon as general counsel unique is that by the nature of his position, things that are coming before him are of an attorney-client and work product nature, presumptively, particularly in this circumstance where on December 12th, 2022, the plaintiff sent a demand.
So what are you asking to do? I understand that.
What I'm saying is that, and your honor will appreciate this from the last hearing regarding PulteGroup when we talked about ESI and proportionality. For Todd Sheldon, he's unique because we haven't been through the thousands of documents yet, but all or nearly all of his documents are going to be of some type of privileged nature. So we would submit that it's disproportionate to ask those documents of him when you're going to have years of privileged documents, particularly after that demand came in on December 12th, 2022, and you've been in litigation as of 2 days later for now a few years, as well as, there's 14 non-parties that have been subpoenaed by them. I'm representing 12 of them.
Right.
And so there's constant privileged communications that have been going on. So Todd Sheldon, the objections really should be sustained for him based upon how the burden outweighs the need with respect to the general counsel. Now, before December 12th, 2022, so it'd be February 1st, 2021 through December 12th, 2022 would be the timeframe we're talking about.
Yeah.
Still, a lot of the documents are going to be privileged, but we will do our best to do a review of them. But I would still submit, Your Honor, because of his position and because of the nature of what he does, and the reason that he would be on a communication is going to be presumptively privileged. Maybe there's an exception.
What about the rest of them?
Okay, so the board members?
Yeah.
All right. So with respect to the board members, there are 6 because 3 didn't have any.
Mm-hmm.
There's very few documents that each of them have. But what Your Honor, what we've been able to determine is that the board was brought in after their demand on December 12th, 2022. It was a big deal at the company. It's somebody who had just been promoted to potential COO of the company. And there's a threatened lawsuit. And then the lawsuit's filed 2 days later. So the board convenes multiple times that week. The communications, as far as we've been able to determine, are all related to attorney directed or attorney present communications in response to the demand of a threatened lawsuit. So
All right.
we're saying that requiring those folks to, go through years, although we think that there's only going to be the board related conversations that relate to the threatened lawsuit or the actual lawsuit once filed would also justify the disproportionate nature of this request. And therefore, these board members also should not have to produce based upon that premise, but also the fact that, these are just not relevant given the claims that really exist in the case.
Okay.
I'm sorry, what did you say about relative about the claims?
That they no longer exist in the case.
Thank you. He trailed off. Thank you.
And this is Carrie Savage for the plaintiff again.
So address the general counsel, if you would, quickly. And then the other folks, I'd like to know if, what your position is on that.
So as to the general counsel, I would emphasize again that it's not his only role with the company. So he does serve in other capacities. However, I appreciate the distinction between the before and after this conduct was reported. I would say at a minimum for after this conduct was reported and after there was a reasonable anticipation of litigation, any communications they had with third parties would not be presumptively privileged, So I think that's a pretty clear and easy way. If there are responsive documents that's not, that is not effectively talking to PulteGroup, it's not going to be privileged.
So communications Mr. Shelton had with third parties about Jones, is that what you're?
Well, about the Jones's Twitter activity or about plaintiff or about the
Okay.
any communications that he had with Brandon to the extent not
All right.
privileged.
So we're not limited to that for Mr. Shelton. That seems to make sense.
Well, the only thing that I would,
Your ruling was?
No ruling yet, about to be, but,
You said
what I'm
something about
thinking,
limited.
yes, what I'm thinking is, limit Mr. Shelton's to communications with third parties about Jones. Obviously, you can look through that, and if there's something in there you want to claim work product or attorney-client, you can do that, but you'll need to provide a log.
And that's only after the reporting time period, so December 12th, is that correct?
It's the whole ball of wax. Okay, you can circle back to Mr. Shelton sometime later if you think so, but he's general counsel. Let's be sensitive there. All right.
And so is it only about Jones or is it also about Pulte? Plaintiff.
I'm sorry. I didn't understand you.
I'm sorry.
So you want,
This is Carrie Savage. So the requests that we asked for were the subject matters of each would be about Pulte, my client,
William Pulte, okay.
communications with Brandon Jones and the individual, so Todd Sheldon, or communications about Jones's Twitter activity.
Yeah, all of that's fine with
Okay.
third parties.
Okay.
Okay. All right, and then what about the other folks?
As to the other folks, I've addressed the relevancy thing. I think the only thing that's new here is Mr. Raven is suggesting that to the extent you were to grant Jones's motion to dismiss our tortious interference claim, that it wouldn't be relevant anymore. I don't think that's accurate because the argument that they've made.
You don't need to
Okay,
spend time.
don't
on
need to do that. Is there anything else you would like me to address as to
Just
them?
potential privilege issues with those folks
So
or work product.
So again, we could address that by definitely including communications to third parties. I'm not sure that, or can we maybe do some exclusions, like excluding Todd Sheldon or excluding people who were a part of those communications as for the investigation?
Okay. All right. So, anything else? So the objections are overruled in part and granted in part. As to Mr. Shelton, we'll proceed with the limitations that have been seemingly, I think, agreed upon with respect to the balance of the folks. Communications with Mr. Shelton are obviously excluded. All of the communications should be turned over. You're welcome to do a privilege log. And as to the rest of the folks. Okay, you got 3 people that have nothing. So they can, I mean, I don't know, what are you proposing there? Just that, I mean, I accept Mr. Raven's statement on their behalf. Do you need more than that?
I'm surprised to hear that, some do and some don't, but that's the representation that he's made. And of course, if, further discovery proves otherwise, we'll address it at that point.
Okay. Yeah, I think that's satisfactory. You represent each of those individuals, right?
I do.
Okay.
And Your Honor, I just need to address the reference you just made to a privilege law. Under case law in the fourth DCA as well as elsewhere, third parties responding to a subpoena are not required to do a privilege log. And, part of that has to do with the burden that would be imposed upon non-parties. So if there are, and there will be, privileged documents, we would have to submit those in camera.
Okay.
I'm sorry, submit those?
In camera to your.
So, all right, if I think we're probably going to approach a point where there's just an overwhelming amount of documents. I see that coming, the iceberg moving. Have you guys agreed on maybe a special master to review privileged? In particular, I think that would be a really good idea here. Maybe like Judge Hazuri or, somebody along those lines.
We haven't. We had discussed it briefly in the past about some of the ESI issues, but we're a non-party here. Multiple non-parties here, but we're willing to entertain that for sure.
Okay, that would be like, there's a few people that I think would do a really good job for both sides.
I'm just, this is not I don't have standing or my arguing on this other than the comment that Your Honor made, if I may. This is Barry Postman. I have no problem with the special master. As Your Honor is aware, we need hearing time, and that's one of the issues in the case, and the discovery is taking away from that. The only concern I would have would be the cost. The plaintiff is the one seeking this vast discovery. And if they want it and they want the burden of it, if they want it, I think they have the burden of paying for it. As it relates to my client, I don't think should have the responsibility of paying for a special master to review thousands of pages.
Well, you guys have to agree, as you know, so you talk and see if you can work it out. And
that would be my only concern. I have no problem with the concept. It's the cost that would be the issue.
I understand. Okay, that's why I was thinking maybe as to the privilege issues wouldn't be too bad, but okay. What's next?
I believe next up is defendant's objections to the notice of intent to serve subpoena on Jonathan Grunberg.
Okay.
I'll be arguing that, Judge. This is Barry Postman. Mr. Grunberg is counsel of record on behalf of Mr. Jones. He has filed a pro hoc, which Your Honor granted. Once my firm came involved, he was co-counsel as opposed to lead counsel. They've served a subpoena on him. I assume Your Honor's read the objection in the papers.
I don't remember it. If I read it, I don't remember it. So you need to fill me in.
Okay, so the plaintiff has served or notice of intent to serve a subpoena on one of the lawyers who's defending Mr. Jones in the case. And that concept in and of itself is something that we obviously have a problem with. What they've sought is in fairness, they've sought non-privileged information as it relates to their claim that Mr. Grunberg has done something with regard to being a PR expert or specialist in the case.
Okay.
And by the way, that's patently false. Let me start off by saying that. But the concept of subpoenaing a lawyer who's currently actively representing a party, it's just problematic. As I said to Ms. Savage outside, if the judge overrules my objection, the next thing I'm going to do is send a subpoena to you for your non-privileged information. And then what you're going to do is send a subpoena to me for my non-privileged information. And then Mr. Rabin is going to get one at some point also. I just don't think that's how litigation generally works, Your Honor. And a lawyer shouldn't have to go through the expense and time to go through their file to find out what is and what is not privileged. Candidly, we think it borders on harassment that relates to it. And we've suggested that in our papers because, as Your Honor is aware, there's other litigation in other states between the parties for which Mr. Grunberg is involved. So we would ask the entirety of the subpoena for documents be sustained.
Well, correct me if I'm wrong, but if he's representing him, wouldn't whatever he has in his possession, custody, or control be something subject to production in any event?
if it was asked of Mr. Jones.
Yeah.
Correct. I agree. We raise that argument as well. Meaning if they want something from Mr. Jones, they ask Mr. Jones for it. Send the whole concept of sending a subpoena.
All right,
We think it's harassment, Judge.
okay.
Judge, I'm addressing this objection. This is
Okay.
Jason Gordon.
Yeah, all right, go ahead.
Thank you. Judge, there's an important
I'm
distinction
sorry.
here as to
Who's speaking?
Jason Gordon.
I'm sorry. Thank you.
Yep, no problem. So, Judge, there's an important distinction as to what's being sought here than what I acknowledge the scenario that Mr. Postman paints of the difficulties of that, of each law firm wanting all communications the other ones have. That's not what this subpoena is about. They acknowledge, as Mr. Postman just said, we're not seeking attorney-client communications, yet their objection addresses that and raises the issue as a basis to oppose it. Now that seems to be off the table. What's being sought by way of the subpoena, for example, is among the categories, the items include communications that Mr. Grunberg has with, I'm looking at request 1, non-privileged documents and communications, including but not limited to communications with media outlets, reporters, PulteGroup, and or Sharon McDonald concerning plaintiffs. The basis of this is communications that are being had with third parties. And here's why this is a little different than the scenario Mr. Postman paints. The issue here is we have the gag order, which Your Honor entered last year. And what Mr. Jones has done through Mr. Grunberg is obtained a declaration from Sharon McDonald that they are using as a basis to seek an order to show cause related to that gag order, claiming that there is a violation. Ms. McDonald has filed a declaration they're using in support of that. Mr. Grunberg communicates with her and obtains this. At the same time, the other side of it being they've put it at issue because they're using Ms. McDonald to support this request they have. They've put these communications at issue as to what's going on there as well. Secondarily, for the media outlet part of it, we have obtained information that it appears that there's communications that are going on between Mr. Grunberg and Real Deal. Real Deal is a media outlet that's focused on the real estate markets. And we had raised at a prior hearing, Your Honor, concerns we have because the gag order was being used by PulteGroup to ask media outlets or sort of strong arm them not to be talking to our client, William Pulte, where this is part of his business. He's in the real estate market and is out there and speaks to media outlets regularly about what's going on in the real estate market. And they're using that to block him from being able to do that because media outlets don't want to talk to him based on the gag order. So we had brought the issue to the court that this is what's happening. And to the extent that there are communications that are going on, if Mr. Grunberg is having these with media outlets that is furthering that purpose, whether indirectly doing what PulteGroup is doing or what Mr. Jones may be seeking, we have claim for tortious interference. If they're using this gag order in interfering with Mr. Pulte's business interests, again, this is different than we just want any communication Mr. Grunberg has, it's privilege or something of that sort. This is sort of narrowly tailored and focused to what's going on with third parties. Now, the position they raise, aside from attorney-client, they seem to have backed off of is work product. There's two types, as Your Honor is aware, fact and opinion. This is an opinion. We're not seeking Mr. Grunberg's opinions on his views of the case. We want to know what he's communicating with this third party for an affidavit that they've obtained, that they've attached to a request for getting an order to show cause. We have the right to explore that as to what the basis is and what they're doing. To take the position it's work product, as we say in our papers, if we were getting this from Ms. McDonald, it's certainly not work product coming from her, the same email she has with Mr. Grunberg. So it undercuts their position on that. And it certainly is, in fact, work product. But the bottom line of it, Your Honor, is we cite to in our papers, we cite several cases, one of them being case we cite to Medina versus American Airlines, 209 Southern 3rd 61. The work product privilege evaporates once the party claiming the privilege elects to use the material at trial. Now they say, well, that's trial. We're not at trial. That part is irrelevant to the basis of the cases we cite in that you waive it. For example, if they had an expert, they were going to be using a trial and they eventually designate them as a consulting expert. You have no work product for that in the communications with the expert. We have the right to see the file. What did you talk about? What did you do? What are the opinions? You're using it, you waive it. It's no different. It doesn't matter. This isn't trial. They want to use it to seek an order to show cause, but we don't have the right to get to the bottom of it as to what's in this affidavit in the communications. So ultimately, they claim it's not relevant. We believe it is. We've explained why it is because they put this whole thing at issue at this point. And the last aspect is they claim that it's going to be burdensome for what Mr. Grunberg's going to have to go find. There's no affidavit or declaration from Mr. Grunberg to that point. He has a declaration or affidavit, but not addressing that. But this is not what you've spent the last hour and a half hearing about discovery and ESI and hundreds of gigabytes of data. This is one attorney. You communicate with media outlets regarding Mr. Pulte. What did you talk to Ms. McDonald about? That's essentially the scope of this. So burdensome. There's no showing, and it doesn't certainly match up in any way to what they've been raising for the other discovery issues here. So they wanted her affidavit. They wanted this. They put it at issue, Your Honor. They're going to do that. We've got the rights to explore it. Mr. Grunberg is the person who is communicating with her to obtain this information. So again, that's why this is different than the usual scenario that I don't dispute of. We don't run around and seek each other's communications as lawyers. That's not how you do it. That's not what's going on here.
Okay.
Judge, that's exactly what to do.
The objections are sustained without prejudice. To seek them from the attorney's files is the primary concern by this court. I will say this much: if you should be able to get these documents if they're sending them out to media outlets or they're out in the public domain, you should be able to get them from other sources. Until you show the court that the source for the information is Mr. Grunberg, his chosen counsel, and that the documents would be otherwise discoverable, I'm going to sustain the objections. I don't think it's appropriate to seek, in the first instance, discovery from litigation counsel, which Mr. Grunberg is. Now, Mr. Grunberg, I will caution you, if things are out there in the public, your media statements and things like that, and we have an evidentiary hearing, that could change. You don't need to respond to that. I'm just telling you, be careful. Okay?
Your Honor, can I clarify one thing to that ruling just for where this is going to go on the record? We'll go do that if that's where we need to go and go to the third parties directly. And they say that in their papers. Nothing stops us from doing it. But if this is going to be that we now do that and they're going to object again and we're going to do this dance again, the same thing, and not be able to get it, I'm just noting on the record that if that's where it is, that's not how this should play out. If they say go to the third parties, we should be able to do that and not continue to do this dance of discovery every time we try and get something.
Mr. Gordon, if judges could issue like blanket rulings that would cover discovery for the rest of the case, trust me.
What a wonderful world it would be.
Yes. You're reading me like a book. Okay.
I asked that we change the order and argue the motion to dismiss. I see that it's 20 minutes before noon. And your order, and I'll be honest, your order was to do it chronologically, and that's what we've done because we weren't able to agree.
Well, I mean, can anyone come back at 1? We got, I have a meeting with Miss Johnson at 12 o'clock, which I intend to be at.
I didn't even let you roll in the papers. I can't come back to 1 because I have another, unfortunately, appointment. I would allow you, I have no problem. Your Honor has read everything and we've argued this 3 times. I would allow you to roll on the papers on the motion to dismiss. I just.
Okay. How do you guys feel about that?
Your Honor, I'll let Ms. Savage address it because she's addressing part. I'm doing the motion to dismiss. She's doing the motion to strike.
Well, I could argue it now. Yeah, that's okay.
That's up to them on both counts.
I'll defer. I'm not involved in the order. I'm just arguing it. So I just, whatever they want to do.
Well, the agreement was to do in chronological order if the parties can agree otherwise. So I mean, that's our position, is that we've got to go in order that things have been.
I'm sorry. You said that's our position?
Yes, I'm sorry. That it's our position that the order says it will go in chronological order. So we would rather be able to address the older items first.
What about, Mr. Postman's suggestion that the court rule on the papers?
If our options are argue it now or submit on the papers, we would rather argue it now. Or we can wait till the next hearing and argue it then. So we would rather
How
not
about,
submit on the
how about
papers.
1 o'clock?
So I just have a 1 o'clock call with the client, Judge.
Well, you were gonna let me handle it on the papers.
I'm
Why
happy to do that.
don't you pass it on to one of your colleagues that could be here at 1 o'clock?
Your Honor, I have a mediation at 1:30. As long as I can be out to make it, that's fine,
Okay.
because I'm arguing part of this.
So,
All right.
Judge, I Kobayashi Maru, right? I'm not gonna win on this. I think he's a great young lawyer and I admire him. You can put this on the record. This is Barry's Postman talking about Hunter.
That was on the bottom of a coffee cup. Okay? It's not that.
Judge, I think you can rule on this on the papers, but if they want to have argument, I think I need to argue it. That's my position. But if they won't agree to it now, I can do my best to cancel the 1 o'clock that I have and say the court wants me here at 1 o'clock. I can do that.
Your Honor, we're really not trying to be difficult. It's just like the next thing on here is the motion to stay, which has caused significant delay, and we just can't continue to delay that. But we're happy to set another hearing very soon about the motion to dismiss.
So that's what's in between this and the motion?
We have that and a motion to strike as well.
How about we do the motion to stay and then we'll do the motion to dismiss?
Okay.
Okay?
Okay, that sounds good.
It's denied. All right, now let's do the motion to dismiss.
The motion stays denied?
Yes.
Excellent. One other thing, I'm sorry, Your Honor. I don't know if I didn't get a clarification from you or if I just didn't write it down. But on the Sheldon and Ford documents, is there a deadline for them to produce those? We would strongly like a date certain for production.
All right. It's not gonna happen.
Your Honor, first of all, microphone. Announce yourself.
Your Honor, Elliot Kula, appellate counsel, limited appearing as appellate counsel for
We get the tough tasks.
I understand Your Honor's ruling. I was candidly expecting it. This is not our first rodeo. But I would ask of Your Honor is if you could allow us just a few days of a stay so that when I get back to my office, I can file my motion with the fourth DCA in an ordinary course, as opposed to having to file it as an emergency motion.
Absolutely fine. How much time do you need?
If I can have 7 days, I'll file my motion for stay by the end of the day tomorrow. And you know how these things go. By Monday, the fourth DCA will issue a temporary stay.
If they're gonna do it, they'll do it. And if they're not, they'll usually say no.
Yes. I just wanted to make sure that I didn't have to run back to my office and file an emergency motion and then call Ron and tell him.
No, we don't have to do that. Thank you. I'm sorry. I didn't mean to, that I definitely did not mean to cut off. I was gonna say, if we argued it, I was gonna say, you guys need to take this to the fourth and see what they want to do.
I was fully anticipating it and I was going to jump right to this point. So I thank you so much for your time and I will be on my way if I may be released.
Absolutely. Thank you for being so courteous about that. I appreciate it.
Thank
So
you.
we're talking a week from today.
Yes, denied with 7-day temporary stay.
Go see what the fourth wants to do. That's fine.
And Your Honor, to the extent the fourth denies the stay as well, what is the timeline for the production of those Marshall documents?
Okay.
They were due July 22nd, so.
Yeah, they're not. Yeah, you can. I mean, there is no stay.
Right. And so after 7 days, it's immediate production?
No, there is.
sorry.
I'm sorry.
There is.
After 7 days?
Yeah, do you need me to, you're asking me to stay it for 7 days?
I'm asking, yes, for just that temporary stay of 7 days so that I can take this request to the fourth DCA.
Okay, so 10 days after that, so 17 days from today. Okay,
Okay. And for the Sheldon and board documents, are those a 10-day turnaround from today?
that's
I'm
all,
sorry,
that's
I did
also
not
gonna be on the agenda?
No, I'm sorry, Your Honor. I didn't get it. We already argued that about you ordering documents from Sheldon and the board members. I was just wondering what the deadline for that was.
Mr. Raven, what can you do?
Your Honor, with respect to Mr. Sheldon, there's going to be a massive amount of privileged documents. With respect to the board members, there'll be a limited set. So for Mr. Sheldon, we're going to need 30 days.
I thought we were, okay, I'm on the wrong person here. So you need a stay for Mr. I thought we were talking about Marshall.
Yes, we were talking about Marshall. I'm just trying to go back and clarify because I failed to get a date
I'm
certain
sorry.
from you.
Confused.
Okay,
Okay.
so we talked about with Marshall, they have 7 days to stay it, and then if
We're subject at that point to whatever the fourth DCA does with your honor.
Or not does.
and if they deny, then they will have 10 days to produce.
Okay.
And so that's with Marshall. I was just going back because it was my mistake. I didn't.
You better go.
We can go.
I very much appreciate you. No problem. By the way, if there was ever a day, I thank God I'm an appellate lawyer. Today is.
Yeah, you're gonna be busy.
Yes.
All right, take care now. Enjoy your weekend. Mr. Raven? I'm not sure what
I think we took things out of order. I think I understand it, that Ms. Savage is asking for clarifications to the number of days.
Yeah.
Right, Mr. Sheldon and the 6 board members that have some documents would have to produce.
They haven't been served yet, right?
They have. They
They
have,
have. Okay,
Yes.
I thought that, okay.
because,
Wow. All right.
yes, because we accepted service on their behalf. So given Mr. Sheldon's going to have thousands of documents reviewed for privilege, we would ask for 30 days for him. For the board members, we'd ask for 15 days.
Hope it's easier than that with how we changed it, but okay.
Yeah.
30 days? 30 days?
Sheldon,
Yes,
and then 10 days for the rest.
we said 15, but
Oh, I'm sorry. I didn't catch that.
Let's do 15. Waited this long, you might as well wait a little longer. Okay.
Thank you, Your Honor. I'm sorry I didn't get that clarification sooner.
It's no problem. Okay.
Start the motion to dismiss.
Yes, sir. Let's do it.
Okay, Judge, thank you, Your Honor. I'm assuming Your Honor has read the papers.
I did, but hit the highlights. Tell me obviously,
I'll be brief, Judge.
yeah.
This is a motion to dismiss a third amended complaint. So by counting, this is the 4th attempt at pleading a cause of action. We're seeking dismissal not of the entirety of the cause of action, just with regard to the tortious interference claim. And at this point, we're seeking it with prejudice. Judge, we believe, I think I don't have to cover the factual background of this case at this point. This is a defamation case involving certain tweets.
Yeah.
As I've indicated to you,
They throw you into the single action rule.
I went through this in detail with you last time. I showed you the cases. Your Honor gave them the opportunity to plead, and you said, I don't know if Your Honor remembers it, plead what additional or different damages. Judge, you were very clear in terms of saying that, and they didn't do that. They did add allegations, but not with regard to damages.
Right.
The single issue rule dictates, and it was on a motion to dismiss. I hope Your Honor remembers the case I showed you that actually dismissed the cause of action. And the second thing I would argue, Judge, just be
I think
brief.
I remember the case, huh? No, I don't, but I know the law.
Okay, so then I could show you the case, but we went through it in detail last time, and it's all on the record.
Okay.
Is the shotgun pleading, and I don't know if Your Honor remembers this, what they've done is they've encompassed everything into each cause of action.
They're willing to fix that one, though.
I would argue, Judge, we've given them an ample opportunity, but yes, Your Honor, if you wanted to give them that chance, they would. The primary argument is a single issue rule, and we need to narrow the focus of this case. I think it may save us some time in what the other issues are, and we think it's pretty clear that this is what should happen in this case, Judge. He has the right to make his claim under defamation, and he has, and we're going to argue it.
Okay.
I have a motion to strike, but I think this should be taken separately.
So the strike wasn't the reallegation, it's something else.
It's new, it's the motion to strike has to do with certain allegations in the complaint. It's not going to affect the causes of action.
Those
It's
are the ones you say are just for publicity's sake.
more than that, Judge, but you want me to argue that now?
No,
Yeah.
let's one at a time. Ms. Savage,
Mr. Gordon is actually going to be handling the motion to dismiss.
Mr. Gordon?
Yeah, thank you,
Okay.
Your Honor. So we've heard the single action rule argument 3 times. You've denied it twice. They keep coming back, hoping at some point the same exact argument sticks. What you said at the last hearing, Your Honor, and they attached the transcript to their motion.
Yeah.
What you said is, I really question dismissal at this stage with respect to, it seems like an election of remedies is more appropriate, but the cases say what they say. So you rejected this. There's nothing that has changed this claim and now allows us to be raised yet again. The argument that we haven't separated out the damages isn't looking at what is now the differential between the defamation and the tortious interference. The defamation claim is based on the interference with Rancor Ventures, Clearview Capital, companies that Mr. Pulte and his company, Pulte Capital, had business with that ultimately didn't happen or fell apart, what's alleged there. The relationship, as far as in the tortious interference claim, is not those. It is the relationship he had with PulteGroup. And what is alleged, as we cite to in our paper, is paragraphs 247 to 251, talks about the relationship that Mr. Pulte had with PulteGroup, the expectancy of continued business. They provided him a letter in February of 2021, thanking him for his service, expecting to do business in the future. And then Mr. Jones goes on his Twitter campaign about Mr. Pulte, and this business relationship then falls apart. There are different business relationships that are alleged. It is not the same, but we've already addressed this. And coming back to it again doesn't change that the argument they've raised fails substantively because they've raised it. We got to deal again. The main case addressed by both sides, Your Honor, at the hearing was the Callaway Land versus Canyon Lakes case from the 4th District. And the basis of this rule is you can't use it, for example, to get around a statute of limitations defense of defamation, which is 2 years and tortious interference is 4. You can't use it if you lose on your defamation claim because there's defenses, immunity and such. You can't avoid that by coming in with tortious interference. But we have a defamation claim. We haven't lost on it. That is still in this case. So the premise upon which you're trying to use this rule fails. Again, the third time we're now arguing this. As well, they try and draw a distinction that Mr. Pulte individually can't seek damages for what he has with Pulte Capital, his company. But pointing to paragraphs 247 to 251 in our papers, the expectancy with PulteGroup is specifically alleged to be including Mr. Pulte individually as well as his company. It's not limited to Pulte Capital, so that frankly doesn't work. As well as paragraph 38, after Jones launched his malicious and defamatory online harassment campaign against Pulte, Pulte's relationship with PulteGroup Board of Directors changed overnight, not the company, Mr. Pulte individually. That's a factual allegation that is incorporated into this claim. As far as the shotgun pleading, yes, we'll fix it. To clarify what Mr. Postman said, you gave us a shot. I want to clarify this, Your Honor. We have not had 3 instances of shotgun pleading. Somewhere there was an error made, I guess, in the amending of this one that instead of what was previously just the usual factual allegations, it changed to the prior counts coming into it. There was an error made. We'll fix it. That's a no-brainer. But this didn't happen 3 times. It's suddenly now they've raised it, and we've done that previously. That's not what happened. That's an easy fix. Bottom line, they keep saying they want to get to the heart of this. Let's do so already, Judge. Let's close the pleadings. Let's have them actually answer instead of raising the same arguments over and over again we've heard. And let's get to it if that's what they want. This should be denied. And then have them please answer this count, and we can go forward.
Judge, this is Barry Poston speaking. We answered the other causes of action. I want to make sure it's clear. This is your quote. I want you to clearly allege the different harms that you suggested you got. Your quote. It's just a matter of the harm being different. And then you said, this is what he stopped reading. So I'm going to follow those for the moment. And that was the law that talked about the single issue rule. Your Honor told them what to do. You gave them the chance, and unfortunately they have been unable to do so. The law is pretty clear on this point, Judge. They can bring their defamation claim, and if they prevail and show damages, they can get it. The single issue rule and the case law, 4th DCA case on a motion to dismiss, dictates what I think Your Honor should do here as it relates to this cause of action. They have been unable to allege different harm. You told them to. At this point, we think it should be dismissed with prejudice.
Okay, so what I want you guys to do is submit proposed orders. I'm gonna look at the allegations regarding the damages. If they're duplicates, Mr. Gordon, I don't like your chances, but that's what I'm gonna look at.
We got one more issue, Judge. This is the motion to strike. May I approach?
Yeah, I want proposed orders by noon tomorrow, okay? Keep them simple.
Okay.
It's not
Judge,
gonna-
I'm in trial tomorrow. I'd have to defer to Ms. Savage if she can do it because I won't be able to. And I don't mean to put her on the spot, but I'm getting ready for trial and I'm tied up all day.
Okay,
I'm going to be in Gainesville.
Realistically.
I mean,
you gotta be there. All right, what are you, Gator?
I'm Kane, Judge.
Canes.
Yeah.
Yeah, my daughter went there, but I am going to the game. I'm gonna see some old friends. I will be wearing Gator stuff just to for protection.
There's going to be 4,000 of us sitting in a corner wearing king stuff. I'll be one of those 4,000 people, Judge.
Watch yourself. I'm sure you'll get a nice, yeah. Okay, what can I do for you?
I'm gonna approach this.
Yeah, excuse me, Your Honor. I mean, this is plaintiff's motion.
Yeah.
I would like to just make brief comments. I promise I'll
No,
be.
this is my motion. This is my motion to strike.
What motion we're doing, Mr.
Oh,
Beal?
I'm sorry. I'm sorry. I was confused. Yes.
Okay,
I'm sorry,
So-
who just spoke?
this is your motion to strike?
Yeah, it was incorporated within the motion to dismiss. This is Barry Postman speaking. Can you hear me if I
Sorry.
stand?
1 second. Who spoke to Mr.
That was-
Postman just
That
now?
was Bill Beal.
I'm sorry.
That was Bill Beal.
So you want me to, the ones that are highlighted, those are the ones you want me to strike?
The tabs.
Okay,
Judge, I'm gonna stand here. This is Barry Postman speaking. We filed a motion to dismiss and a motion to strike certain allegations within the third amended complaint. As your honor is aware, 1.140, which is the rule, says if something is immaterial, impertinent, or scandalous, I think that's the quote from the rule, it should be stricken from the complaint. We're asking that certain of the allegations be stricken. As your honor has seen, I've given you the complaint. It's 85 pages. It contains a significant number of allegations that are irrelevant, impertinent, or immaterial, and candidly scandalous.
okay.
As we cited in our paper, the fourth DCA has said that a lawsuit is not, it's not for purposes of there being a press release. As your honor is aware, and I think it's relevant, there has been significant amount of social media activity with regard to allegations, and we believe the same is relevant to these. Paragraph 6, Judge, I'm going to be very specific. I gave you the first highlight to make it simple. An
Okay,
allegation that my client is having a romantic affair with Stephanie Byron. Judge, there's no reason for that to be in the complaint, none. I don't even know if it's relevant to the case, none. But because they're alleging it, and this is what, sorry, so that's the first one, judges, paragraph 6. You want me to keep going or want to do one by one?
no, I want you to have Mr. Hunter prepare an order that will have, as to each paragraph, why you would propose that I strike it, and Ms. Savage, you do the same on the other side of it. Now, as to each one of these, I need to know why they're in the complaint and why they belong in there.
Understood, Your Honor.
Mr. Hunter, you're gonna tell me the others, why it belongs out of the complaint, okay?
Thank you, Judge.
Yep, no problem. I'm gonna hang on to this, okay?
Yeah.
It's helpful for me to loop through it, and I will, so let's say, well, I know I'm granting part of the motion to dismiss because you're gonna get rid of the reallegations, Mr. Gordon.
Yep.
So how much time do you all want to, revise your complaint?
By the way, if you grant them, I'm sorry, 1 second, counsel. If you grant the motion to dismiss and the tortious interference, no issue with regard to the single action, the shotgun pleading.
I understand. Okay,
So if it's just the shotgun pleading rule, we need a nominal amount of time, I believe. But if
I'm sorry.
so you're gonna send me an order tomorrow. I'll put 10 days just to be on the safe side.
I
And
don't
how
know what
much
you
time?
said. The
I
female
said 10 days, Jennifer. And Mr. Postman, how much time to answer? That's the direction
We
you go.
already answered, so this would, if you deny it, to answer
Well,
the,
they're gonna amend, they would have to amend and you'd get a new complaint.
yeah, if all they're amending is the shotgun, 10 days, let me just be 10 days.
10 and 10. Okay,
There's one more motion if you want to argue it. I'm happy to stay 10 minutes.
well, okay.
Yep, we're happy to do it. It's a motion, it's our motion to strike and.
Yeah, that's fine. Ms. Johnson, you're excused. I'll see you in about 15. Okay, we have our
It's up to you, Your
committee
Honor.
meeting. No, it's okay. Go ahead.
Are you sure? Okay. It's a motion to strike that actually, Mr. Beal is taking.
I'll be short, Your Honor. So
Okay.
In this motion, it involves a statement by Jones in a filing with the court in which they put in quotes, a quote mark of something that Mr. Pulte allegedly said on social media and then deleted. And it was completely invented. This is not a misquote. This is not, he said something close to it. It was completely false, okay? Mr. Postman filed an amended motion taking that part out and noting he had a good faith basis to put it in, which just inferring, I'm not asking Mr. Postman to reveal any attorney-client privilege information, but I think we can assume he got this from the defendant, Mr. Jones. And so this quote was very damaging, and our position quickly is that the amended response doesn't cure the problem based on a quote that, from someone who was terminated for dishonesty. There's now a false quote in there. It puts Mr. Pulte in a false light, and he can't really correct it in the public domain because, Your Honor, the gag order, he doesn't want to try to run afoul of that.
I understand.
And so all we want, and I believe in the response, Mr. Postman agrees, but all we want is that prior pleading actually be stricken and removed from the public record.
Okay, Mr. Postman.
Judge, this is a motion that is a complete waste of your honor's time. They advised me about the issue. I immediately corrected it. I dropped a footnote saying I corrected it. They then said they're going to report me to the Florida bar and they're moving for sanctions against, which is going to be the subject of another motion. I agreed. And I said, if you want it off the record, take it off the record. But this is the attacks that this case has become, unfortunately, in terms of where it's unfolded. But yes, once you told it to me as an officer of the court, I fixed it. I corrected it without there being, before the motion was filed.
Do you care if there's an order striking it from?
Not at all.
Okay, go ahead and prepare your order, Mr. Beal.
Thank you.
Yeah.
I just, as long as there's not sanctions against myself or Mr. Walker.
Yeah, don't do that.
Yeah, we're not asking for that.
Okay.
Yeah.
All right. No, I think you said it very professionally. I don't know what happened behind the scenes, but I appreciate that. It's how to handle it.